So guys, welcome. So today we are doing a digest on civil procedure rules, where we have drafted all the necessary applications required per the order and per the rule. We have also attempted to predict application questions pursuant to each order and rule. So let us jump into the work and see what we did. So basically that is the preliminary pages. So I decided to combine Order 1 that generally talks on parties to suits, on who may be joined as plaintiffs, power of court to order separate trial, who may be joined as defendants, court may give a judgment or for, against or more of joint parties. Then we have defendants need not be interested in non-relief claimed, then joinder of parties liable on same contract, then when plaintiff in doubt from whom redress is to be sought, then 8, one person may sue or defend on behalf of all in same interest, then 9, we have misjoinder and non-joinder. So basically when it comes to civil litigation, you will not be asked to define various sections in verbatim. So you realize that we have taken a diversion as compared to the Law of Succession Act, because the Law of Succession Act requires, together with the Advocates Act, requires a deeper reading section by section. But when it comes to civil litigation, they want you to deduce the applicable application pursuant to that order. So in this situation, let us look at how various courts have interpreted this order so that we get the gist, so that when we are also drafting, we have a background of various situations on what can influence our application to be drafted before court. So in this situation, basically, courts have decided to interpret. Let me note something here is causing disturbance. Yes. So in this situation, various courts have decided to interpret Order 1 of the Civil Procedure Rules, purposively to avoid multiplicity of suits. So joinder is allowed where claims arise from the same transaction or series and raise a common question, and misjoinder or non-joinder rarely defeats a suit. So courts instead cure it by joinder, amendment, or ordering separate trials. So those are the tools that the court can use to prevent a situation where a person is trying to defeat a suit merely by bringing misjoinder applications or misjoinder claims. So the court will cure it by joinder or seeking amendment or ordering separate trials. So governing rules that you need to take note is that if you check Order 1, Rule 1 and 3, so joinder of plaintiffs and defendants. So the twin threshold is 1. Right to relief arising from the same act or transaction or series, and 2, if separate suits were filed, a common question of law or fact will arise. So this informs you whenever you're doing a joinder application, you need to confirm that you have the twin threshold that has been laid before you. Is there a right to relief arising from the same act or transaction? And if each party were to file a suit, it will have been a duplication of suits because it is giving rise to a common question of law or fact. So the other digest is where we have Order 1, Rule 2 of the Civil Procedure Rules, where separate trials to avoid embarrassment or delay. So where joinder may embarrass or delay trial, court may order election or separate trials. So this is the right reserved to the court to cure any embarrassment or delay to the wheels of justice by ordering election or separate trials. So the other key takeaway that you ought to take note is Order 1, Rule 8 of the rules, where we have representative suits. Where numerous persons have the same interest, suit may be brought by or against one or more as representatives, but notice to all is mandatory in the manner directed by the court. This is where the court allows one to bring a suit on behalf of a community or of a certain number of people, but you must have served due notice to them because it is mandatory. Then if you read Order 1, Rule 9 of the rules, we have misjoinder or non-joinder is not fatal. So a suit is not defeated by non-joinder or misjoinder. So courts determine the controversy as between parties before it. So let us look at various judicial interpretation of how various cases have tried to bring reasoning to these rules. So if you read the decision known as Frederick Wanyonyi Simiyu versus Helen Maindi Kibabane, the court allowed joinder where the grievance arose from the same transaction and there were common factual questions. It stressed that defendants need not all be interested in all relief and liabilities need not be the same. So this basically same transaction plus common question will lead to a joint application generally being allowed by the courts. So if you take another look at various other decisions, because when it comes to civil litigation, we are not interested in knowing the citations of this decision because they are merely procedural in nature. So Moses Mukuria decision, the court refused to strike out merely for misjoinder, relying on Order 1, Rule 9. It accepted joinder where claims arose from a series of transactions and common issues will arise. That is a retaliation. Then we have also a decision when it comes to representative suits where they have same interest is key, but notice is not optional. So courts typically cure by ordering advertisement or service rather than dismissal. So in as much as the notice to these people who are being represented in this one suit, being the fact that you need to serve a notice being mandatory, the court will still not order a dismissal of the matter. Instead, it will order for advertisement of the same so that it cures that technicality. So what are the practical steps that you ought to deduce from Rule 1 all the way to 9? So what a same transaction are serious and common questions mean in practice. So courts look for a real overlap in factual matrix or legal issues, but not superficial similarity. So typically, we have to consider joinder-friendly patterns in the following situations. One, in one event, there is an accident, fire, publication, tender or raid affecting multiple parties. Then in number 2, we have one cause of dealing, whether it is about fraudulent disbursements, repeated supplies, tenancy disputes in same premises. Then another situation we can see is uncertainty as to the liable party. So join in the alternative under Rule 7. Whenever you have uncertainty as to the liable party, you will be allowed to join the other party being an alternative person. So when courts sever Order 1, Rule 2 instead of refusing joinder. So severance or separate trial is likely to occur where 1, evidence becomes unmanageably different per party. Then number 2, joinder creates procedural unfairness or confusion and even delay and prejudice. And thirdly, where separate quantification of damages and issues is needed even if a liability is common. So lastly, we have representative suits. What are the key takeaways is that you must show numerous persons are affected and they have same interest and relief is beneficial to the class of people. So you must seek a leave or elections and obtain a notice order or where you have to effect personal service or through an advertisement. Non-compliance is commonly cured by directions of the court, but it can derail timelines and expose you to cost. So generally, whenever you are being told to analyze a various in a problem question situation by the examiner, and then you discover that the problem question has brought forth the elements that we have just discussed, then you will just take note that you are required to draft an application under Order 1, Rule 1 to 9 of the Civil Procedure Rules. So generally before you have a notice of motion where you want to seek leave to sue or defend in a representative capacity, then you are also seeking directions for service of a notice to the representative parties. So check at the headings, Republic, blah, blah, blah. So I will not be reading the heading because that is one mark and the heading is consistent to all of our applications. So basically you have to approach court via a notice of motion when it comes to these orders. So you have to attach the enabling provisions. As you can see, it's being brought under Order 1, Rule 8 of the Civil Procedure Rules, Legal Notice 151 of 2010 and all enabling provisions of the law. So take notice, because it is a notice of motion, take notice that the plaintiff or applicant shall move this honorable court on this day at this time or soon thereafter for orders that 1. Leave be granted to the plaintiff or applicant to institute and or prosecute this suit in a representative capacity on behalf of describe those people being numerous persons with the same interest in these proceedings. Then number 2, the court be pleased to direct the mode of notice to all persons represented by 1. Public advertisement or such other mode as the court may deem fit. 3. Any person on whose behalf this suit is instituted be at liberty to apply to be joined as a party. Cost of this application be in the cause. What are the grounds that the examiner will be looking at? The examiner will see whether the persons sought to be represented are numerous and have the same interest in the subject matter of the suit, and B, what is the common question of law and fact that is arising for determination, and a representative action will avoid multiplicity of suits. It is therefore in the interest of justice and proportionality to proceed by representative action in this matter. So what do you support your notice of motion with? You use a supporting affidavit where you reiterate the key contents that will give life to your grounds, where you have description of the class, common interest, appropriate numbers, and why personal service is impracticable, proposed advertisement wording, etc. That is it. That is where you have a joinder for representative suits. Then let us see a joinder for addition of a defendant or plaintiff. So this is a typical joinder application used when a party is necessary for complete adjudication or liability is joint or several, and in alternative or plaintiff is unsure who is liable. So remember, you will be applying rule 7 logic where you are allowed to use an alternative person whenever you are not sure who to sue. So what document will you use? You use a notice of motion being brought under order 1, rule 3, 5, 6 and or 7 of the civil procedure rules and other enabling provisions. What are the languages? What is the language that you will use in this application? That proposed party full name in this be enjoined as the second or third defendant or plaintiff herein, that the plaintiff be granted leave to amend the plaint in terms of the draft amended plaint annexed. Then 3, that the annexed amended plaint be deemed duly filed upon payment of requisite fees and be served within a number of days. Cost be in the cause or to the respondent. Grounds. The key grounds that the examiner will look at is the claim against the proposed party arises from the same act or transaction or series as pleaded. Then B, if separate suits were filed, common questions of law or facts will still arise. Then C, the proposed party's presence is necessary to enable the court to effectually and completely adjudicate the questions in controversy and or determine liability as between all the parties. Supporting affidavit will be used where you identify the transaction show overlaps, and in essence you are reiterating what you had done in a notice of motion. But one key element that we can deduce from the supporting affidavit where you want the court to enjoin a party, either a defendant or a plaintiff, you have to show us that you have duly drafted the amended plaint, because remember, pursuant to order 8 on amendment of pleadings, you have to show that you have duly annexed the amended document so that the court will clearly see and the other party will clearly see to what extent are you going to amend your plaint. So you have to annex. That is one annexure that you can attach in your supporting affidavit. Then how about order for separate trials under order 1 rule 2? This is where you are moving the court to tell it that you, in your exercise of the court's honorable court's inherent jurisdiction, to seek separate trials. So you're doing under a notice of motion brought under order 1 rule 2 of the civil procedure rules, that the plaintiffs be put to their election and or the court be pleased to order separate trials of 1. Claims by plaintiff group A and B, claims by plaintiffs being group B or such other grouping as the court directs, that the cost be provided for. That the grounds is where the marking scheme is that the present joinder is likely to embarrass or delay trial because it has distinct facts, witnesses, defenses, and countable issues. And B, separate trials will promote efficient and fair disposal without prejudice. That is another application that you can still do. What if now you have been told to do an application striking out for misjoinder or misdescription. This is to be used with caution pursuant to Order 1, Rule 9, because Order 1, Rule 9 says misjoinder and non-joinder does not defeat a suit. Courts usually prefer cure and amend or joinder over dismissals. If you must bring it, plead for a curative order, not dismissal. So in essence, I did it deliberately because you already have the content of the notice of motion that is applicable in Order 1, Rule 1 all the way to 9, and I directly delved in the prayers part that misjoinder party be struck out and name corrected as correct entity, that the plaintiff do amend pleadings within a number of days. So if you are to do an application for striking out for misjoinder, don't think that the court will take the dismissal prayer seriously. Dismissal is a thing of the past. The court will cure it by amendment. So, how have courts interpreted Order 10? Order 10 talks about substitution and addition of parties. Well, now you have realized that you have sued the wrong person, or now you want to add another party. What are the key takeaways? Is that Order 1, Rule 10 is interpreted broadly to let the court fix the parties at any stage so the real dispute is determined, but only where the error is a bona fide mistake, not fraud or deceit, and or where the proposed party is a necessary or proper party for complete adjudication. So some key takeaways is that substitute or add plaintiff for non-bona fide mistake. So courts may at any stage substitute or add a plaintiff if satisfied the suit was filed in the wrong name, though a bona fide mistake and substitution or addition is necessary to determine the real matter in dispute. This is pursuant to Rule 10. Okay, so another key takeaway is where you want to strike out or add any party, being the plaintiff or defendant. So the court may at any stage, with or without application, strike out an improperly joined party and add any person who ought to have been joined or whose presence is necessary to effectually and completely adjudicate and settle all questions. Okay, then you have another situation where we have a next friend or persons under disability. These people cannot be added as plaintiffs without next friend or as next friend without written consent. Okay, this is Order 1, Rule 10, Sub Rule 3 of the Civil Procedure Rules. If you want to be joined as a next friend, you must obtain written consent, and you can't join a plaintiff being a person under disability without a next friend angle of it. So if the examiner sees that you have directly sued a person who suffers under disability and is a minor, then the examiner will just know that you don't know what you're doing. Then lastly, we have if defendant is added or substituted, a plaintiff and summons must be amended and served on the new defendant and sometimes originals unless court directs otherwise pursuant to Order 1, Rule 10, Sub Rule 4. So how have various courts interpreted? Just briefly, because it is procedural. Bona fide mistake is a factual inquiry. The rule is to cure genuine misnaming, not to punish technical errors. Then another key takeaway is that court can substitute or add even without a formal application where justice requires, where this now tells you that this discretion must be exercised to bring the proper party before the court. So Order 1, Rule 10 does not sanitize fraud, forgery, or lack of authority. No bona fide mistake, no substitution. Okay, so what are the practical steps that you ought to take keen of note is that A, where you apply under Rule 10, when you're claiming wrong plaintiff or doubtful plaintiff, you must show the following: that the wrong plaintiff name or capacity happened through a bona fide mistake, and substitution or addition is necessary to determine the real controversy, e.g. correct contracting party, registered proprietor, or estate representative. How do you apply Order 1, Rule 10 when it comes to striking out or adding necessary parties? You must show that the person is improperly joined. Okay, this is a wrong entity. You have sued personally instead of the company. I'm just a director. You have not lifted the corporate veil. Okay, 2. The person ought to be joined is necessary so the court can complete or settle the issues, and risk of inconsistent finding or orders will affect them. Then procedural must-dos when adding or substituting a defendant. You have to seek leave and annex a draft amended plaint. So whenever you're doing this application to add or substitute a defendant, show that you are seeking the leave of the court to do this application. Then annex the draft and amended plaint. Once allowed, file the amended plaint plus procure amended summons unless already served and court directs otherwise. Then serve the new defendant with amended summons and amended plaint within timelines set by court. Allow them time to enter appearance or defense. So generally, how do you do an application for substitution or addition of plaintiff pursuant to Order 1 Rule 10? So the title is there. Remember, in the title, you include the name of the wronged named plaintiff versus defendants. Then you have brought under Order 1, Rule 10(1) and all other enabling provisions. Take notice that the plaintiff or applicant shall move the court for orders that 1. The court be pleased to substitute the plaintiff herein. Give the current name with the correct name and description to or add correct name of the plaintiff or as an additional plaintiff, because it is we are doing an application on a substitution or additional of a plaintiff, so any can apply. So the plaintiff or applicant be granted leave. Remember, you must seek leave. The plaintiff or applicant be granted leave to amend the plaint in terms of the draft amended plaint annexed hereto, and the same be duly filed upon payment of requisite fees. Cost of this application be in the cause to the respondent. Failure for you to seek leave, the amended plaint will not have any effect before the law. Grounds: the suit was instituted in the name of a wrong person. It is doubtful whether it was instituted in the name of the right person due to a bona fide mistake. Remember, you have to emphasize on a bona fide mistake so that it can be granted. The proposed plaintiff is the person in whom the cause of action or right to relief vests and whose presence is necessary for determination of the real matter in dispute. So no prejudice or incapable of compensation by cost will be occasioned. Any prejudice can be cured by corresponding leave to amend or respond to my amended plaint. Obviously, supporting affidavit, what you need to show is plead how the mistake occurred and annex the draft amended plaint. Then there is another application where you strike out a wrongly sued party and substitute with the correct defendant, still under Order 1, Rule 10, 2 and 4. So this application is being brought under Order 1, Rule 10, 2 and 4 and all enabling provisions. So that the name of wrongly joined defendant be struck out as defendant for being improperly joined, that the correct defendant name and description address be added, substituted as the defendant in place of the wrong defendant. So you are striking out and adding. The defendant be granted leave to amend the plaint. Remember, that is mandatory. Leave must be sought. The plaintiff do file and serve the amended plaint and amended summons, that the new defendant be granted a number of days for reply. Grounds that the examiner will look at: the defendant currently on record is not the correct party. The proposed defendant is the party who ought to have been sued. Remember to attach the bona fide angle. The amendment or substitution will not occasion injustice. It will avoid multiplicity and ensure enforceable orders. What are you attaching in your supporting affidavit? Whether it is a company, CR12, a title, an next draft amended plaint, show why wrong defendant is wrong. So prove to the satisfaction of the court. Then what happens when you add a necessary party as additional defendant? No striking out. So used where current defendants remain, but you need another party to be joined, e.g. a registered proprietor, insurer, guarantor, or personal representative. I delved down to the priors that you will seek. Let this person be joined as the second defendant. Let me granted me leave to amend plaint. Amended plaint be filed. Joint defendant to file appearance. So once you have started seeing that this application is in a repetitive manner, the language of the drafting itself is slowly getting into your mind, so that you can draft this application even when you have closed your eyes. The mistake that students will do, they will cram various templates, but they will not have any language to use, how you insert in various applications. So remember, we said that whenever you want to add a person on behalf of a minor or a person under disability, you have to show that there is a written consent, because failure for you to attach a written consent of the proposed next friend, then the same will be fatal. You cannot sue a minor or a person under disability. So maybe students usually omit this crucial document by the fact that they have just merely drafted an application and a notice and supported by an affidavit, and forgetting to say that the supporting affidavit has annexed herein, and you also go to the extent of drafting a simple consent to act as a next of friend. So these are the tricks that we want to decode when we are drafting these applications. Now, Order 1, Rule 11. In respect of government proceedings. So, in respect of civil proceedings by or against the government, this order shall have effect subject to Section 12 of the Government Proceedings Act, which relates to parties to such proceedings. So, at times the examiner will tell you that one entity has caused breach to a private individual, and this entity appears to be a government entity or department. So Order 1, Rule 11 means if you sue or are sued by the national government, joinder or substitution under Order 1 is constrained by the special who is the proper party rule in the Government Proceedings Act. Ordinarily, you sue the government through the office of the AG unless another statute lets the specific entity sue or be sued in its own name. So, governing rules, we have Order 1 applies to government civil proceedings subject to the Government Proceedings Act. Then, default proper party, civil proceedings by or against the government shall be instituted by or against the office of the AG. This is pursuant to Section 12 of the Government Proceedings Act. Then, if you read proceedings instituted against the AG office do not abate by change of office holder. This is pursuant to Section 12(2) of the Government Proceeding Act. Judicial interpretations. If you sue government officers or department without the AG, where the claim is truly against the government, the pleading or application can be struck out as incompetent. Then, where relief effectively operates against the government, courts require the AG to be joined or served and will cure by joinder or amendment directions. So, exception. If another written law makes the body a corporate entity that can sue or be sued, AG is not automatically necessary. That is a decision known as Wanyama versus Lungari and GCDF committee, where the AG not necessarily where the sued entity is a body corporate capable of suing or be sued under its constitutive statute. Courts treated Section 12 of the GPA Act as subject to any other written law. So if an examiner tells you that this is a parastatal that has been duly incorporated by a certain legislation, by a certain statute, then you go directly and say that you are going now to inform the AG. No, you don't know about this decision, Wanyama versus Rungari. AG is not necessarily where the sued entity is a body corporate capable of suing or being sued under its constitutive statutes. So, when Order 1 or Rule 11 bites, so ask, is the defendant a government department or officer being sued for official acts, and will the decree be executed against the government? The answer is yes. Plead and align parties to the suit is against the office of the Attorney General, or ensure AG is at least properly joined or served, depending on the enabling statute. Ask, is the target entity established as a body corporate with capacity to sue or be sued? If yes, you can often sue that entity directly. AG may be unnecessary unless the statute otherwise requires. What is the document to use whenever you want to join or substitute the Attorney General as a defendant, regularize a government party? So look at the title clearly. So the current defendant is the County Commissioner Land Registrar. Then The enabling provisions, we have a notice of motion being brought under Order 1, Rule 10.2 and Order 1, Rule 11 of the Civil Procedure Rules, and Section 12.1 of the Government Proceedings Act, Cap 40 and all enabling provisions of the law, because you are bringing Section 12 to show that this entity, this person, forms part of the government. That can be a mark to that examiner's paper. What are the prayers that you will be seeking? That the Honorable Attorney General be enjoined or substituted as a defendant herein on behalf of the Government of Kenya, that the plaintiff be granted leave to amend the plaint, then that amended summons be served, the AG be granted a number of days to serve, to reply to the same. Then, what are the grounds? The acts or omissions complained of were undertaken by the existing defendants in their official capacity, and the proceedings are in substance against the government. Then, by virtue of Section 12 of the GPA Act and Order 1, Rule 11, the proper party is the office of the Attorney General. Then, joint or substitution is necessary to enable the court to effectually and completely adjudicate all questions arising in this question. And then when it comes to supporting affidavit, you can identify the official capacity of this person or entity, show how decree will run against the government, and annex the draft amended plaint. Another application that you take note is that where we have striking out wrongly joined public officers and you want to join the AG. So used where a public officer is sued personally for official acts. So what are the prayers that you will seek? That the name of the officer be struck out as a defendant for being improperly joined in a personal capacity, the actions complained of being official and governmental duties. The AG be joined or substituted as defendant pursuant to Section 12 of the GPA Act. I seek leave to amend my documents. Then we have preliminary objection or motion to strike out for failure to sue through AG. Because courts often prefer cure by joinder or amendment, ask for alternative reliefs. So the orders that you can seek in this situation is that the suit be struck out for want of a proper party against Section 12 and Order 1, or in the alternative, that the plaintiff do within 7 to 14 days amend to join or substitute the AG, failing which the suit stands to be struck out. So whenever you want to seek a striking out order, you attach it in the alternative orders that you will be seeking before the Honorable Court. So where the entity is body corporate, a response to join the AG application. So now this is where you are responding to a person who has sued the AG when the entity is a body corporate. So you just directly use the words as we have outlined before you. So conduct of suit. So if you look at Rule 12, the court may give the conduct of the suit to such person as it deems proper. How is this part relevant? Let me see whether there is a document arising from the same. There is a document, and this document is being brought by chamber summons. So this is a very critical part. We must understand its application. So Order 1, Rule 12 lets the court decide who among multiple parties on the same side will take conduct of the suit, i.e. give instructions or appear, plead or act, and courts enforce it by requiring written authority. Where one plaintiff purports to act for others, non-compliance can be fatal. So court's discretion. The courts may give the conduct of the suit to such person as it deems proper, pursuant to that Order 1, Rule 12. In practice, this is implemented through the authority to act mechanism. Where there is more than one plaintiff or defendant, one or more may be authorized by the others to appear, plead or act, and that authority should be in writing and filed. The rule courts apply as Order 1, Rule 12 authority. So written authority is mandatory where a few plaintiffs act for many. Failure can lead to striking out. Okay, so the High Court struck out a suit brought by 5 tenants on behalf of 700 others for failure to file proper written authority signed by those being represented. Substantial compliance may suffice where intent is clear and no prejudice is shown. So courts accept a less formal written authority where there are names, thumbprints, and clear intent, and dismissed a preliminary objection on Order 1, Rule 12. Point number 3 that you take is that if all persons are specifically named and have given written authority, a representative suit application may be unnecessary, but authority still matters. So ELC has held that Order 1, Rule 8 leave was unnecessary where represented persons were named and had written authority. So in essence, if the examiner is to bring a situation where you have representative suits, and this representative suit you are acting on behalf of 10 other people, the document that the examiner expects a student to draft is a written consent to act on behalf of the names that the examiner will provide. Failure to do that, it is fatal, and you have seen in the decisions before you. Failure to attach a consent of a next of friend is fatal. That will also lead to a striking out of your document. What is the appropriate synthesis of this part when to invoke Order 1, Rule 12? You invoke Order 1, Rule 12, where multiple plaintiff or defendants want one or few to run the case. You have instructions, appearances, and pleadings, especially in land or community, tenants and group claims, SACCO and church disputes. What courts expect on record? They expect a written authority that is duly signed by each party authorizing the named persons to act, and if parties are numerous and not all are named, served. Consider Order 1, Rule 8 on representative suit directions noticed by advertisements. Okay, so if you happen also to have numerous people that you are representing, remember we saw that service is mandatory and the court can order or give directions for service upon them. So what is the draft application that you can draft to court, seeking direction that conduct of suit be given to name the plaintiff and defendants pursuant to Order 1, Rule 12. And we see clearly we go under a chamber. Why did I write? Also, it is okay. It is okay. You can use chamber summons or notice of motion. Remember, the default application rule is a notice of motion unless where the rule expressly state about a chamber summon. So, notice of motion is being brought under Order 1, Rule 12 of the Civil Procedure Rules and all enabling provisions, seeking that the court be pleased to give the conduct of this suit on behalf of the plaintiffs to the following people: that names be authorized to appear, plead, sign instructions, and take all steps necessary for the prosecution of the suit on behalf of the plaintiffs. That the written authority executed by the plaintiffs and filed in court be deemed duly filed and on record. What are the grounds? The plaintiffs are numerous, more than one, and it is expedient that conduct be vested in one person. The plaintiffs have executed written authorities consenting to the said persons taking conduct of the matter. No prejudice will be suffered. It will reduce delay and cost. You attach a supporting affidavit where you attach the proof of authority to act. So, how is an authority to act? How does it appear? It is just before you. Authority to appear, plead, and act or take conduct of suit. This is what you attach to together with the application for conduct of parties under Order 1, Rule 12. So we, the undersigned plaintiffs in civil suit, hereby authorize the following people to appear, plead, and act for us and to take conduct of the suit, including giving instructions to advocate, receiving documents, and doing all acts necessary for the prosecution of this suit. So generally, this key point number 3 is where we have respondent's notice of motion or preliminary objection, challenge for lack of Order 1, Rule 12 authority. So these are the prayers that you will seek if you're the defendant and you have realized that the plaintiff have no authority to act. The pleadings or steps taken by the named plaintiffs on behalf of others be struck out for want of written authority under Order 1, Rule 12, or in the alternative, that the plaintiffs be directed to file proper written authorities within a number of days, failing which the suit or will be struck out. So the grounds that you will be stating is that no signed authority, there is a mismatch between claimed represented numbers and actual signatories, as was seen in Philocona decision. So generally, how do courts interpret Order 1, Rule 14? Any application to add or strike out or substitute a plaintiff or defendant may be made to the court at any time before trial by chamber summons or at the trial of the suit in a summary manner. So Order 1, Rule 14 is purely procedural. Before trial, you bring joinder or striking out or substitution by chamber summons. Now commonly a notice of motion in practice, but that is debatable. But at the hearing, the court can deal with it summarily. You can also do it orally on the spot without a full interlocutory application, so long as the other side is not ambushed or prejudiced. So I remember our civil litigation lecturer telling us that oral applications are dangerous because what if the prayer is refused, then you want to appeal the order of the magistrate. So that is fatal because you have to wait for the proceedings to be typed, and Otif he omitted to state it clearly as you had pleaded. So you'll encounter challenges when you do oral application. So go with written applications. So the governing rules is that Order 1, Rule 14 provides that any application to add or strike out or substitute a plaintiff or defendant may be made any time before trial by chamber summons or at trial in a summary manner. Okay, so because the rules have directly stated a chamber summon and the examiner has directly told you that the suit has not yet commenced, so use a chamber summons. The examiner will not know that whether you use a chamber summons or notice of motion, you have to be cured under Article 159. The marking scheme can be strict. So key takeaways from judicial decisions, we see that court freely substitute the proper party and then orders amendment and service or directions. Then once a defendant is substituted, added, filings made before amendment or service can be premature. Then leave to add parties is required. You cannot simply amend in a defendant without a leave. So generally, before trial, this is the normal rule: file an interlocutory application under chamber summons, and at trial, in a summary manner, you can use oral or make a normal application. So chamber summons or notice of motion being brought under Order 1, Rule 10, 2, and 14 of the Civil Procedure Rules, a prayer that you are seeking to add a defendant before trial. So if it is before trial, let us state chamber summons. That the name or description of the parties be joined as being the second and third defendant, that the plaintiff be granted leave, that the amended plaint have attached herein be duly filed upon payment, amended summons be served, and cost be in the cause. Then what are the grounds? Is that the proposed defendant's presence is necessary to enable the court meet the ends of justice. Then chamber summons where strike out wrongly joined parties and substitute a proper party before trial. That is what is to be used. Then oral application at trial. At times you will encounter a question in trial advocacy. Kindly make an oral application at trial. What is the language that examiner expects you to say? Expects you to say that my lord or my lady, person to Order 1, Rule 14, read with Order 1, Rule 10.2, we apply orally that this name be struck out or substituted and enjoined. The evidence now on record shows 1, 2, 3, 4 facts. The proposed party is necessary for complete adjudication. We pray for direction that the pleadings be amended within this number of days, that amended summons be served on the new defendant, and that the new defendant be granted number of days to respond. We are content to pay throwaway cost. So that is an opening statement when you are referring to a trial advocacy unit. So, Order 1, Rule 15, notice to third party and subsequent parties. Okay, this is also a highly tested scenario. If you have managed to go through civil litigation papers, you cannot miss a third party application question. So Order 1, Rule 15 is a third party procedure. A defendant who wants contribution or indemnity or closely connected relief or issues against a non-party must seek ex parte leave within 14 days after close of pleadings. If you skip leave or delay without explanation, the notice is liable to be struck out. So governing rules is that a defendant may seek third party where it claims 1. Contribution or indemnity, B. Substantially the same or connected relief as the plaintiff's claim, or C. A common connected issue that should be determined between all the three. This is what forms the ground that you will rely upon in your application that is to be drafted. What is the timeline? Apply within 14 days after close of pleadings for leave to issue a third party notice. The leave application is by summons in chambers ex parte supported by affidavit. This is also provided under Rule 15. Close of pleadings is generally 14 days after service of a reply or defense to counterclaim, or if none, 14 days after service of defense. This is also an oral question. When do we consider close of pleadings? We usually consider close of pleadings generally 14 days after service of a reply or defense to counterclaim, or if none, 14 days after service of defense. Okay, this is provided for under Order 2, Rule 13 of the Civil Procedure Rules. a very notorious question when it comes to the oral examinations. Then after leave, file a copy of the notice and serve it like summons, stating nature and grounds of claim, and serve a copy of the plaint. Unless otherwise ordered, file serve the notice within 14 days of leave. Sub-rule 4 to 5 allows fourth party and beyond third party may issue its own third party notices mutatis mutandis. So there is no barrier that a third party cannot introduce another fourth party. Another key takeaway from this part is that we have seen leave must be sought for you to be granted now these directions to bring a third party to the case. So judicial interpretation, no leave equals to defective notice, and the same will be struck out. The court struck out a third party notice issued without first obtaining leave under Order 1, Rule 15. Delay can be excused. Discretion turns on explanation, justice, and avoiding multiplicity, where the High Court allowed late third party proceedings, emphasizing comprehensive determination of liability and avoiding a fresh suit. Then court dismissed an ex parte application filed outside timeline with no good explanation for non-compliance within the 14-day window. So that is a strict application. It's a 2023 decision. So you cannot say that that was a mere technicality. So what marking scheme will the examiner look when you are drafting? Indemnity, they look for contribution, and then they look for common issues arising, and that the issue should be determined together. Let us look at how this document is to be drafted. The rules have directly stated that we use ex parte chamber summons, leave to issue to third party within time. So Republic, so that is the heading, constant, then ex parte chamber summons being brought under Order 1, Rule 15 of the Civil Procedure Rules and all other enabling provisions. Let all parties concerned, these are chamber summons, let all parties concerned attend the judge in chambers on day of 2026 at this time for orders that 1. The defendant or applicant be granted leave to issue a third party notice to the intended third party, and the third party notice be filed and served within 14 days, and 14 days of grant of leave or such time as the court will direct. Then what is the supporting document? Remember, when it comes to ex parte chamber summons, you could have stated the grounds thereunder that you are seeking for indemnity, contribution, and the basis is that it is arising from same facts and issues. So what is the supporting affidavit coming to do? It is coming to annex any contract that you are relying upon and other enabling documents that will prove contribution, indemnity, and connected relief or common issue that is arising. So another application still where you have been granted leave and you are pleading for leave and enlargement of time to file out of time. So the examiner in this situation has told you that a person intends to bring a third party, but they have realized that it is 20 days past after you have been granted leave of the court to do so. So you are out of time. So you need to enlarge time. So use when 14 days after close of pleadings has elapsed. So it is tied to after close of pleadings have lapsed. So additional praise that you seek time for filing the application for leave under Order 1, Rule 15 to be enlarged and the application be admitted as duly filed. So this is where you have realized that 14 days after close of pleadings have lapsed and you have not sought leave to bring a third party. So this is what you must take be keen on, that you request leave and in the same application you seek enlargement of time. Then third party notice. How will this third party notice appear? Okay, at times an examiner can give you a 15 or a 10 marks question, then you wonder why the 10 marks and yet you know you'll just draft an application. So the examiner may be wanting you to draft a third party notice. Third party notice will appear as follows. To whom? Okay, the first is the title under Order 1, Rule 15 of the Civil Procedure Rules. To whom is it being addressed? To the third party that you are proposing to bring. Take notice that in civil case number this, the defendant claims against you for the following, the grounds that you are relying upon: contribution or indemnity in respect of the plaintiff's claims, or connected relief, then clearly state, and or determination of the following common questions on issues and list the same. And take notice that unless you enter appearance within the time prescribed and take such steps as the rules require, the court may proceed and determine the issues as between you and the defendant and make such orders as may be just. That is a third party notice. Now, how do you draft a motion by a third party to strike out third party notice? Common defense application when it comes to the CLE examination situations. Now you are representing the third party that has been served with a third party notice. So you do a notice of motion pursuant to the same orders that the prayers you are seeking is that the third party notice dated be struck out for want of leave or late filing and not triable claim under Rule 15(1). Cost to the third party. What is the ground that you are relying on? No leave obtained, and the same is out of time with no explanation and no arguable basis for contribution or indemnity or no common issue. What happens when you want to issue a notice, a third party notice to the government? Okay, Order 1, Rule 16. Notwithstanding anything in Rule 15, leave to issue a third party notice for service on the government shall not be granted unless the court is satisfied that the government is in possession of all such information as it reasonably requires, so as to the circumstances in which it is alleged that the liability of the government has arisen, and as to the departments and officers of the government concerned. So, in essence, we have another threshold that we need to prove when we are serving the third party notice upon the national government. So Order 1, Rule 16 raises the bar for third party proceedings against the national government, where leave will be refused unless you show the government already has or has been given sufficient particulars of the alleged liability and you have identified the responsible departments or officers. So governing rules, we have special threshold for government being as a third party. Then we have the same information required is mirrored in the pleadings against the government that is in their custody. Then leave refused where the defendant is fishing for information, government involvement was not shown. Then where the government is being brought as a third party after leave, objections based on government notice requirements may be treated as arising from service or joinder stage. So generally that is it. How do you draft an application for leave to issue third party notice to government? So the title remains, remember it is as ex parte chamber summons. What are the prayers is that the defendant or applicant be granted leave to issue a third party notice for service upon the government of Kenya through the Honorable Attorney General, and in particular name the ministry or government and officer, that the third party be filed and served within 14 days. What are the grounds that you will be seeking upon? Is that they are the ones in custody of this information and are not fishing for this information. Supporting affidavit, pleadings timeline and clause of pleadings, nature of plaintiff's claim against you, your claim against the government, you want contribution and indemnity, and then check the compliance under Rule 16, that is circumstances of alleged government liability, and the department and officers being concerned, clearly identify them. Then how is a third party appearing when you are serving to the government? You serve the same to the Honorable Attorney General, pursuant to Order 5, Rule 9, and Government Proceedings Act mechanisms. Take notice that the claim against the government of Kenya through the Attorney General and specifically state the ministry and department or an officer where you seek indemnity, contribution, or connected relief is arising from a similar transaction or event on the grounds set out below. Particulars of Government Act, causal link, and contract or policy that has been violated. Then the third party AG ground of opposition, now you are representing the government, is that applicant does not identify department or officers or particularized alleged government liability, and application is just a fishing expedition. Information can be obtained by summons or witness production. Where you want to call an EACC officer, you don't necessarily do a third party proceeding because you'll just take out summons to a witness, as we will be able to see. No arguable indemnity or contribution, common issue under Order 1, Rule 15. Then default of appearance by third parties. What happens in case of default? If a person not a party to the suit who is served as mentioned in Rule 15, hereinafter called the third party, desires to dispute the plaintiff's claim in the suit as against the defendant on whose behalf the notice has been given, or his own liability to the defendant, the third party must enter an appearance in the suit on or before the day specialized in the notice, and in default of his doing, he shall be deemed to admit the validity of the decree obtained against such a defendant, whether obtained by consent or otherwise, and his own liability to contribute or indemnify, as the case may be, to the extent claimed in the third party notice, provided that a person so served and failing to enter an appearance within the period fixed in the notice may apply to the court for leave to enter an appearance, and for good cause. Such leave may be given upon such terms if the court thinks fit. So generally, a third party who is properly served but fails to enter appearance by the date in which is indicated in the third party notice is treated as having admitted, 1, the validity of any decree against the defendant, and 2, its own liability to contribute or indemnify to the extent claimed, subject to the court's discretion. Then key takeaways is that a third party who wants to dispute 1, the plaintiff's claim against the defendant, or 2, its own liability, they should do so before the date that is indicated there. So that is a reiteration. How do we defendant's notice of motion deemed admission under Order 1, Rule 17 after default. So this is where the examiner tells you that a person was duly served with a third party notice, and this third party has since not entered appearance even after service of the same, and you have annexed a duly served a duly executed affidavit of service, and you have attached before court. So what will you do thereabout? So you bring an application under notice of motion being brought under Order 1, Rule 17 of the Civil Procedure Rules, where you will be seeking the prayers that the court be pleased to find that the third party, having been duly served with the third party notice dated this date, and having failed to enter appearance within the time stated therein, is deemed to admit, 1, the validity of any decree obtained against the defendant in this suit, and 2, its liability to contribute or indemnify the defendant to the extent being claimed in the third party notice. 2, that the court do give consequential directions and orders on entry of judgment as against the third party and cost. So supporting affidavit, you attach the leave order under order 1, then you attach third party notice, then affidavit of service, then prove no appearance was ever entered. Then third party's notice of motion, leave to enter appearance of time. So the third party has realized that somebody is doing an application so that judgment can be entered against him. Then he is out of service, is out of time. We have seen a provision where the court will consider his application. That the third party application be granted leave to enter appearance and file its response and pleadings out of time. That the deemed admission, if any, and all consequential proceedings and orders as against the third party be set aside and vacated pending inter partes hearing and determination. That the next draft memorandum of appearance and draft defense or statement of defense to third party notice be deemed duly filed and cost be in the cause. The reason why you are attaching memorandum of appearance and statement of defense at the same time is because, remember, you want to be granted leave to enter appearance and file your response. So it is to the interest of the court to see that you have indeed attached the necessary document being the defense and memorandum of appearance, because for you to have a locus standi before that court, we must see a memorandum of appearance. Then third parties grounds that they will be seeking, that they no proper leave under Order 1, Rule 15 was served. Then he is saying that the third party notice was irregular. Then no proper service upon him. So maybe he was never served and good cause exists. Request leave under the provision. So default of appearance by government as a third party. What if it is the government that is in default of appearance? What will you do? Order 1, Rule 18 means the government does not suffer the automatic deemed admission consequence in Order 1, Rule 17 as a third party unless you first obtain a specific court order. You must seek that order by chamber summons served at least 7 days before the return day. Governing rule is that no automatic default admission in third party proceedings against the government. Order 1, Rule 17 does not apply unless the court so orders. So procedure notice period, the application for the Rule 17 shall apply Order must be by chamber summons and must be served not less than 17 days before the return day. Then this mirrors the wider no default against government without leave plus 7 days service principle in rules. Okay, Order 10, Rule 8. Judgment in default against government requires leave. Application served more than 7 days before return day. But I believe there is a decision that declared that provision to be unconstitutional, as we will see when we get to Order 10. So courts treat government involved default steps as non-automatic and insist on the special leave plus proper service safeguards before any default consequences are imposed. So I told you civil litigation does not require many stories. Draft the application. So now you are saying that the government is the third party and they have failed to enter appearance. What will you draft? You will draft a chamber summons that is being brought under Order 1. Rule 18 of the Civil Procedure Rules. Take note of how parties appear when you are suing a third party. You introduce versus the defendant, plaintiff, and the Honorable Attorney General for the Government of Kenya being the third party. Okay. So let all parties concerned attend the judge in chambers on this date for orders that 1. This Honorable Court be pleased to order that Order 1, Rule 17 shall apply in these third-party proceedings against the government through the Honorable Attorney General. Cost be in the cause that the grounds are that the government through the Attorney General was duly served with the third-party notice dated this date, together with the plaintiff, and has failed to enter appearance within the time stipulated. Unless Order 1, Rule 17 is applied by order of that court, the defendant or applicant will be prejudiced and may be driven to multiplicity of suits despite an extant third-party claim for indemnity and contribution. It is just and proportionate that the government be bound by the consequences of default in circumstances of this case. So leave order under Order 1, Rule 15 and Rule 16 if government information threshold was involved, that party was properly served. So important to note is that this chamber summons must be served on the AG not less than 7 days before the return day. Okay, so consequential notice of motion deemed admission after you obtain the Rule 18 order. So file only after prayer 1 above is granted. Prayer number 1, you are seeking leave under Order 1, Rule 15. Okay, because you have seen when you want to enforce the consequential orders against the third party being the government, you first seek leave, then you serve the third party notice, then once you have served, you file another application under notice of motion, and this time you will do so when you have been granted prayer number 1 on the leave. That pursuant to the court's order dated this date, made under Order 1, Rule 18 and Order 1, Rule 17, the government as the third party be deemed to admit the validity of any decree obtained against the defendant and its liability to indemnify or contribute to the extent claimed in the third party notice. Direction on entry of judgment be given. So judgment against third party in default. So remember the first situations, we were making applications against the third parties for default. Now we want to see what judgments can be made pursuant to third parties who have deliberately omitted to appear before court. So Order 1, Rule 19 lets a defendant who has issued a third party notice obtain judgment against a defaulting third party for that indemnity or contribution being claimed, typically after the defendant records satisfaction of the plaintiff's decree, though the court may enter third party judgment even before satisfaction, and the court retains power to set aside the judgment. So what is the key takeaway? A court should enter interlocutory judgment against a defaulting third party under Order 1, Rule 19. Failure to follow the third party procedure makes resultant judgments vulnerable on appeal. Okay, if the third party notice is irregular or was issued without leave under Order 1, Rule 15, any judgment against the third party is unsafe and will be set aside. So failure for you to seek leave, then the examiner will know that you will not qualify to pass this civil litigation paper because you will be a danger to the society. So what is the application that you will draft when you are seeking judgment against that party in default. Now you are seeking under Order 1, Rule 19. So this is the application that you will make. You bring a notice of motion under Order 1, Rule 19 of the Civil Procedure Rules, prayers that the court be pleased to note that the third party, having been duly served with the third party notice dated this date, and having failed to enter appearance and or file pleadings, and the defendant having suffered judgment by default, the defendant is entitled to judgment against the third party. That certification of the decree in favor of the plaintiff against the defendant be entered upon the record, if not already recorded, that judgment be entered for the defendant against the third party for this amount, being the extent claimed in the third party notice dated this date. Then you attach the necessary documentations to support your applications. Then judgment before satisfaction. Use where you haven't yet recorded satisfaction, but you want a Rule 19 judgment now. So this is the alternative prayer that you will insert. That the court be pleased pursuant to Order 1, Rule 19, to enter judgment against the third party before satisfaction of the decree against the defendant undertaking to satisfy the plaintiff's decree, and to file proof within X number of days. Then the third party has realized that judgment has been entered against me. The rule still provides that he can come to set aside and vary the judgment. Listen to the prayer that he will make. He will say that the judgment entered against the third party on this date, under Order 1, Rule 19 be set aside, that the third defendant be granted leave to enter appearance or file its pleadings within number of days. So maybe the core ground that they are relying upon is irregular third party notice, where there was no leave or no plaint was served, and lack of proper service or good cause and triable defense to counter the indemnity and contribution angle. Now, no judgment against government without leave of the court. Now you failed to obtain leave through the chamber summons, then you do the notice of motion application against the government after expiry of 7 days and after being granted leave by the court. So failure to follow that step will mean that no judgment against the government without leave of the court will be applied. So you cannot obtain or enter judgment against the government as a third party under Order 1, Rule 19, unless you first get the court's leave under Order 1, Rule 20 by chamber summons served on the Attorney General at least 7 days before the return day. So mandatory leave is so it is mandatory to request for this leave. A defendant shall not be entitled to enter judgment against the government under Rule 19 without the leave of the court. Then procedure plus minimum service period. The leave application must be by chamber summons, served not less than 7 days on or before the return day. Then this sits within. There are disturbances that are emanating. So this sits within the wider. Let me mute these notifications. So this sits within the wider civil procedure rules scheme that default judgment steps against the government requires a leave and prior service. So no judgment against government. I'm gonna log out. Let me see. So that is what was causing the disturbance. So and in your position, can you hear the notifications? Ringera, unasikia notifications zenye zina arise?
Yes.
Zenye zinaingia?
Yes.
How can I silence them? Jaribu to go to notification settings. Let me go. Then ndika kuzinyamazisha. Mute. Good. On. Mute all notifications. Yes. Okay, so itaisha 3, si ndio? Hiyo nini inaisha 3? Nikumenisha, let me go back. Ndio nipate hiyo record. It is 1 p.m. So let me join. So basically, we were saying that you cannot seek to enter judgment against the government without the leave of the court. So what is the necessary key takeaway in this situation? Remember, for you to be able to enter judgment against the government, you need to seek leave via a chamber summons. So this chamber summons being brought under Order 1, Rule 21 to 2 of the Civil Procedure Rules and all enabling provisions of the law. So let all parties concerned attend the judge in chambers on this date for orders that leave be and he is hereby granted to the defendant or applicant to enter or to apply for judgment against the government of Kenya through the Honorable Attorney General as third party under Order 1, Rule 19 in respect of the third party notice dated this date. The grounds that I want to rely upon is that the government through the Attorney General was duly served with the third party notice and plaint and has failed to enter appearance or file pleadings within time. The defendant or applicant has a lawful claim for indemnity or contribution within Order 1, Rule 15 and seeks judgment under Order 1, Rule 19 but is barred without leave by Order 1, Rule 20. It is just to grant leave to avoid multiplicity of suits to enable complete determination of liabilities. So follow up on notice of motion where judgment against government as third party file after leave is granted. So that person to the leave granted on this date. Now let's say you have been granted leave person to a chamber summons application above. Now you want to do a notice of motion now seeking judgment against the government. So you will move the court person to Order 1, Rule 19, where you say that the person to the leave granted on this date, judgment be entered for the defendant against the government as third party under Order 1, Rule 19, plus interest on maybe the terms that you want to be settled. Judgment after trial against that party in default. So Order 1, Rule 21 lets the court at or after trial or after non-trial disposal enter judgment for the defendant against a defaulting third party, but execution of that third party judgment generally needs leave and is hereby held back until the defendant has satisfied the plaintiff's decree. So generally, for us to understand this part is that after trial and the plaintiff has succeeded, if the third party defaulted in appearance and the suit is tried and the plaintiff wins, the court may at or after trial enter judgment for the defendant against the third party, but execution cannot issue without leave until after the defendant satisfies the plaintiff's decree. Okay, so if plaintiff succeeds otherwise than by trial, the court may, on ex parte application supported by affidavit, order judgment for the defendant against the defaulting third party at any time after satisfaction by the defendant of the plaintiff's decree. So court will not enter third party judgment on its own motion. The defendant must apply. So where the procedure is used between co-defendants, not a true third party, courts insist you use the Order 1 framework rather than a counterclaim, a shortcut. Appellate court will set aside third party judgments entered without strict compliance with leave or service steps under Order 1, Rule 15. Okay, so defendant's notice of motion, judgment after trial against third party in default. So this is how the application will look like. It's being brought under Order 1, Rule 21 of the Civil Procedure Rules and notice of motion. That the court be pleased, the suit having been heard and determined in favor of the plaintiff on this date, and the third party having failed to enter appearance and file pleadings after due service, to enter judgment for the defendant against the third party to the extent claimed in the third party notice dated this time. That execution of the said judgment be stayed pending satisfaction by the defendant of the decree in favor of the plaintiff or if it is urgent, that the defendant be granted leave to issue execution before satisfaction pursuant to provision of Order 1, Rule 21. So, judgment where plaintiff succeeds otherwise than by trial. So, used after consent judgment or summary disposal. So, you move court accordingly, pursuant to ex parte chamber summons or notice of motion. Are you saying that it is being brought under Rule 21 or 21(2) of the Civil Procedure Rules, that the court be pleased to enter judgment for the defendant against the third party to the extent claimed in the third party notice dated this date, this suit having been finally decided in the plaintiff's favor otherwise than by trial, on that the court be pleased to note that the defendant has satisfied the plaintiff's decree and satisfaction has been entered on the record. Okay, so if you need early execution, plaintiff's decree huge and third parties dissipating assets, you need to add that the defendants be granted leave to issue execution of the judgment against kuna echo Ringera, that the defendant be granted leave to issue execution of the judgment against the third party before satisfaction of the decree against the defendant on terms that the decretal sum recovered be applied towards satisfaction of the plaintiff's decree and on such security terms as the court will direct. So generally, appearance of third party and directions. So key takeaways is that Order 1, Rule 22 is the direction stage of third party practice. Once the third party enters appearance, the defendant must move the court for directions. The court then either orders a trial of the third party's liability, often alongside or after the main trial, if there is real and triable question, or if there is no proper question to try, enter judgment for the defendant against the third party. What is the document that will draft? Directions after third party enters appearance. So you will move court via summons in chambers being brought under Order 1, Rule 22. Let all parties concerned attend the judge in chambers on this date for orders that 1. The court be pleased to give direction to the termination of the third party proceedings. The court be pleased to find that there is a proper question to be tried as to the liability of the third party to the defendant in respect of indemnity or contribution pleaded in a third party notice dated this. The issue of the third party liability to the defendant be tried at the main trial together with the plaintiff's claim or after determination of the plaintiff's claim on the basis of the evidence recorded as the court directs. That the third party be directed to file and serve its defense to third party a notice, and then the third party be granted leave to participate at trial. So generally, we have exhausted all angles pursuant to a third party. If you read Order 24, it talks on defendant claiming against a co-defendant. Okay, so this can also be asked. And generally, what is the document that you will use? Are there any tests to be considered? So let us read the summary paragraph. Order 1, Rule 24 allows a defendant to pursue contribution or indemnity or closely connected relief or issues against a co-defendant already on record by serving a notice without leave, and the court then manages it using the third party procedure when it comes to directions, issues, and trial sequences, while preserving the plaintiff's rights against any defendant. So a defendant may, without leave, issue and serve on a co-defendant already a party a notice claiming one contribution or connected relief substantially the same as plaintiff's, or determination of a common issue. So in essence, this rule says that leave is unnecessary. Filing an application for leave is misconceived. So whenever you are claiming against a co-defendant, the examiner will just have a look at your document. You are going directly to seek at his leave, alafu unaanza kusema that you have served a notice. This rule says that if it is a co-defendant already a party to the suit, the leave is unnecessary. You just serve the notice upon the defendant stating the notice of claim for contribution or indemnity. This is how it will appear before you. You will draft pursuant to Order 1, Rule 24. The title is Notice of Claim Against Co-Defendant. So you will say that, remember the parties, angalia the parties, kuna plaintiff, kuna first defendant, then there is second defendant, also an issuing party. So the second defendant is the one issuing this notice to who? to the recipient being the third defendant. So take notice that the second defendant claims against the third defendant, one, contribution or indemnity, then connected relief, that the common issues be determined as between the plaintiff and the second defendant. So up to that point, we have gained a good insight. So directions on co-defendant notice: apply the Rule 22 directions model, summons in chamber, where you say that the court give direction on determination of the second defendant's claim against that defendant under the notice dated this date, that the third defendant do file and serve its response. So that is an application where you will be seeking court's directions pursuant to other application. So generally, order 1 is, from my experience, is that we have briefly touched on all aspects of order 1. We have looked at the thresholds to be applicable to various applications emanating from the same. We have understood the spirit of order 1 and understood all the applications that are to be filed in order 1, either in the government or either against the government, against a co-defendant, where you want representative suits. We have greatly analyzed order 1 of the civil procedure rules. Order 2 is generally talking about pleadings in a general manner. So basically, what you need to understand is generally order 2 rule 4, matters which must be specifically pleaded in a plaint. So order 2 rule 4 is enforced strictly. If you rely on special matters on fraud, illegality, payment release and limitation, or action of God or inevitable accident, etc., you must plead them expressly and with particulars. Otherwise, the court will generally not allow you to spring them at trial and may treat the claim or defense as incompetent. So for us to understand, check at specific pleading requirement. This is pursuant to order 2 rule 4. So specific pleading requirement: any pleading after plaint must specifically plead matters, e.g. performance, release, payment, fraud, inevitable accident or act of God, limitation and illegality, that A, make the opponent's claim defense not maintainable, B, would take the opponent by surprise if not pleaded, or will result to raising new factual issues. So that is a key takeaway. Then recovery of land: in suits for recovery of land, the defendant must plead every ground of defense specifically. Then plaintiff particulars: when it comes to fraud and illegality, pleadings must contain necessary particulars where fraud and misrepresentation is being pleaded. So generally, what you will be required by the examiner is defendants, where you want to do a defendant's notice of motion, where you want further and better particulars. So use when the plaint alleges fraud or illegality vaguely, and you need clear dates and actors. So the law allows you as the defendant to write to do an application for requesting for further and better particulars. Okay, being brought under order 2 rule 10. So being pressed that the plaintiff be ordered to supply further and better particulars of the allegations of fraud and illegality or misrepresentation in paragraph blah 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 of the plaint, including the specific acts and omissions alleged, the persons alleged to have committed them, C, dates and places and documents relied on, and D, the manner in which the defendant is said to be implicated. That the plaintiff do supply the particulars within a number of days, and you attach a supporting affidavit. Then defendant's application to strike out or alternative order amendment, where order 2 rule 4 is breached. So used when fraud or illegality or limitation is being raised in submissions or evidence but not pleaded, or pleading is bare. So you do this application under order 2 rule 15. So alternative relief is that paragraph dash of the plaintiff or defense or counterclaim be struck out for failure to comply with order 2 rule 4 and rule 10, no specific plea or particular. So in the alternative, you plead that the court duly struck out these documents. How do you plead special matters to avoid such applications from the defendant? Okay, where you want to plead limitation, the defendant shall contend that the suit is statute barred under the limitation of actions, the cause of action having accrued on or about and the suit having been filed on this date. When it comes to payment and you want to show proof of the same, the defendant affirms that the claim has been fully settled by payment of this and release discharge dated this date is annexed. Where you want to say about fraud, the defendant denies the allegation of fraud and puts the plaintiff to strict proof. Without prejudice, the plaintiff has failed to plead fraud with particularity as required. So, what other key takeaway that you have to extract? Particulars in defamation actions under Order 2, Rule 7. How do you plead defamation actions? So Order 2, Rule 7 is a pleading discipline rule for defamation. If you rely on 1, an innuendo or secondary defamatory meaning, and 2, justification plus fair comment, or 3, express malice to defeat privilege or fair comment, you must plead the required particulars, otherwise you risk being shut out at trial or having the pleading struck out or treated as bare. So we have various elements to take away is that innuendo or a secondary meaning where the plaintiff alleges the words were defamatory other than their ordinary meaning. The plaintiff must give particulars of the fact or matter supporting that meaning. Then 2, we have justification plus fair comment. If the defendant pleads truth or fact and or fair comment or opinion, the defense must particularize which words are fact and the fact or matters being relied on. So in short, you must plead directly as per the reasonable man's test. So this is particulars of the defamatory innuendo statement. I will not delve into because it is just a guidance so that you can apply the same in your plaint to prevent the same being struck out for want of non-particularity. So particulars of pleading. I'm looking to see whether this is where now the defendant will do a notice for particulars, as we saw earlier when they want to request various particulars that the plaintiff has not complied with in his plaint. This is an application for further and better particulars. We have seen this application can be conducted by the defendant. This we have looked at it. Okay, denial by joinder of issue. What is this? So I believe Ringera at this point, to prevent any dilution of any points, we can proceed pursuant to Order 2, because I can also see striking out pleadings. There are various angles that you can use to strike out a pleading. This can also be asked in orals. This will require us to have a separate discussion before we go to Order 3. So if you have looked at Order number 2, we have to analyze Order number 2 in details so that we prevent a situation where we don't know various ways of attacking a suit. Then we will jump in to Order number 3 when we resume, because I see we have other applications in each order. So I can say up to that point we have exhaustively discussed on Order 1 and Order 2 partially. Then we will also discuss on rules of service to various entities and various recognized means of service. Then we will also look at leave to serve summons, where you want to seek summons, leave to serve summons pursuant to an application. Then we have service of foreign legal processes in Kenya. We have appearance of parties. We have defense and counterclaim. Then we have various applications pursuant to that order. Leave to amend pleading. This is a common one in the CLE papers. We have recognized agents and advocates. That is not common. Order 10, consequences of non-appearance. This is common. Various ways where judgment can be entered against an individual. Interlocutory versus summary judgment. That is a common oral question. That is a common oral question. Judgment in default against the government. What document will you be required to draft? case management conference. What is the purpose of a case management conference? This is an oral question together with a short structured question when it comes to the civil litigation paper. Then we have hearing and consequence of non-attendance, where suit can be struck out where the plaintiff fails to enter appearance during the hearing. We have admissions, judgment on admissions. We have hearing of suit and examination of witnesses. Okay. We have application for an account. We have judgment and decree. We have execution of decrees and orders. How do you execute? We have attachment of movable property not in judgment debtor's possession. The examiner will make sure to see whether you know how to do an application for execution where the property is not in the possession of a judgment debtor. When court may stay execution, what are the timelines? What are the factors to consider in your grounds? Then we have, this is just a summary so that we have a roadmap. Then we have attachment of debts, death and bankruptcy of parties. What happens when there is death and bankruptcy? What is an abatement of suit? Proceedings by or against the government. What are the applications to draft when you are bringing the proceedings against the government? Order 31, suits by or against trustees or execution and administrators. What is an interpleader? Section 34. Order 34. An interpleader is a highly tested application. So this will warrant a further analysis of Order 34 on the interpleader applications. How do you draft an interpleader application? That is duly noted. How do you seek summary judgment? Have I drafted an application? Yes, there is an application on seeking a summary judgment. What are the grounds that the court will consider for a summary judgment to be entered? Order 37. What applications require an originating summon? That can be an oral question. Then can also be a problem question. Temporary injunctions and interlocutory orders are highly and frequently tested area. You have been approached by an auctioneer at your doorstep, and the auctioneer wants to execute. How do you move the court accordingly? How do you draft the application to seek a temporary injunction? How do you move the court accordingly when it comes to appeals? How do you draft a memorandum of appeal? Because some questions require students to draft the necessary documents for appeal. How do you interpret Order 42, Rule 6 on a stay pending appeal? What threshold must you prove before court for you to be granted that order, that stay? Okay, this is where CLE, where Order 43 appeals from orders, a pauper appeals. That is an oral question. A pauper, who is a pauper? A review. How do you do an application seeking review? I have duly drafted. How do you arbitration under an order of the court? Not frequent. Then we have district registries. Now we are on the forms provided by the civil procedure rules. So I have duly noted that there are some highly tested provisions in the civil procedure rules, and we have duly answered them. The only point of additional information is where we have Order 34 on interpleader proceedings. How do you draft this application? What are the thresholds for the court to consider? So I will duly comply with that, so that when we have the next session, That will be on Monday at 9 p.m. Not 9, at 10 p.m. to 11 p.m. We will have mastered the highly frequent applications being brought under the civil procedure rules, so that we embark on this criminal procedure code. Then we jump straight into conveyancing procedures and all the necessary applications in the conveyancing department as read together with the Companies Act and partnership and limited liability situations. So that is it. That marks the end of our discussion today, so that we embark on preparations of past papers for another presentation. So thank you so much, JJ. Let me end the recording.